Hello everyone, welcome to Court with Krissy. Time for an update. This defendant has been here 6 or several times before. If you've missed any of those appearances, I've linked them all in the description. We're kicking this off with a sweet plea deal, and then it's all downhill from there. I hope you like it. Court with Krissy is now in session.
Mr. Brown, were you ready with Ms. Baumgartner's case?
We can do that now.
Okay, let's call that case. I see it looks like Mr. Dick's still talking to his client, so if we're ready on that one. Call People versus Baumgartner. This is file number 266979.
For the record, Charlie, I'm calling back from People.
Mr. Baumgartner, we can have this, or Mr. Brown. Let's have Mr. Baumgartner sit. Might be easier for you to move over.
That's fine. I'll move over here. Okay. All right. Very Brown, okay.
Thank you. All right, the record should reflect Ms. Baumgartner's present here in the courtroom today. And Mr. Brown, I did receive a document which I think indicates that we have a no contest plea agreement.
That is correct, Your Honor.
Can you tell me the terms of that?
Yes, Your Honor. Just one moment here. There has been an offer in this matter to plead to count 2 as a habitual second, and the remainders would be dismissed. I did go over that with Ms. Baumgartner. I also went over potential guidelines with her, and at this time she would enter a no contest plea using the affidavit of probable cause as a factual basis. The reason the factual basis is generally twofold. There is some liability potential because she does have a probation violation, so necessarily violate that if she actually pled guilty to that. She still has that right, and she has some dementia as well, and states she just does not.
All right, Mr. Rolla, is that a correct statement of the plea offer?
It is, Judge, and the people have no objection in the court accepting a no contest plea using the affidavit of probable cause as the factual basis.
Okay. Ms. Baumgartner, were you able to hear everything we just said? Were you able to hear everything we just said?
If I listen closely.
Did you hear what we just?
No.
All right, Mr. Brown, it might be easier since you're closer if you can state the terms of the plea agreement.
The terms of the plea agreement are to plead to count 2 as a habitual second, and count 1 as well as remaining enhancements are going to be dismissed. And we went over potential guideline scoring. Do you recall that? Okay, and you understand the terms of that agreement, and you're going to plead no contest today using the affidavit of probable cause as the basis, correct?
Yes.
Okay, that's what you would like to do today, Ms. Baumgartner? Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can lower your hand. You understand that the maximum possible penalty for this charge as a second habitual offender would be up to 7. I'm sorry, this is a 1-year misdemeanor with this. No,
Is
is it the 5 years original?
Correct.
Okay, so it would be 7.5.
Correct, yes.
Would be up to 7.5 years. Do you understand that?
You have to answer.
Oh,
Okay. All right, and you're going to plead no contest to that charge, is that correct? All right, right now, I'm going to go through your rights with you. Do you understand those rights? And do you understand that you're going to be giving up and waiving those rights by pleading no contest?
yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to do that, you would have to ask for the Court of Appeals to hear your case. If they said no, then you couldn't go any further with that appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead no contest? Has anyone promised you anything other than what we've said in court today?
No.
And is it your own free choice to enter this plea?
Yes.
All right, so I reviewed the affidavit of probable cause. Mr. Rolla, have you done that as well?
I have, Judge.
And would you agree that the information contained within that report would establish a factual basis for count 2?
Yes, Your Honor.
I would
Mr.
agree. So.
So I'm going to mark and admit that affidavit of probable cause for complaint number 26421-00260. That's going to be marked as Court Exhibit 1 and admitted as the factual basis in this case. Mr. Rolla, are you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Judge.
Mr. Brown?
No, Your Honor.
Mr. Rolla, are you satisfied that the court has complied with statute and court rule in the taking of this no contest plea?
Yes, Your Honor.
Mr. Brown?
Yes, Your Honor.
All right, Ms. Baumgartner, the court finds that your plea is knowing and voluntary. The court finds based on the information contained within Court Exhibit 1 that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Mr. DeLeo, are you going to touch base with her before she leaves today?
I will, Your Honor.
So Mr. DeLeo from probation is going to touch base with you before you leave today. It's important that you stay in touch with Mr. Brown, your attorney, prior to that next sentencing hearing, okay? All right, thank you. That's all for today. You're free to go. Have you had any contact with Ms. Baumgartner recently?
Yeah, she's not. I just received.
So let's go on the record on that. All right, we're back on the record. People versus Joanne Baumgartner, file number 266979. Council can put your appearances on, please.
Yes, Your Honor. For the record, my girl, behalf of the people.
Larry Brown, we have Ms. Baumgartner.
Okay, Mr. Brown.
I have been in contact with Ms. Baumgartner. The last was on the 31st of May. I made her aware of the recommendation from PSI with her. I advised her that she needed to be here in person. She stated that she was having health issues, may end up having to go to the hospital. I did advise her, obviously, if she has to go to the ER or whatever, but to be here if at all possible, absent a real emergency. She just sent me something at 2:36, so about 5 minutes ago, that she is in the ER.
Mr. Roloff.
Judge, as the court's well aware, this matter was scheduled specifically for a sentencing. There are 28 impacted victims in this particular case. Ms. Baumgartner, at the time of the offense, was on probation for committing the exact same type of offense again. She has a history of conveniently not being available and having things come up to try and court. Absent any confirmation from a licensed, verified medical facility doctor, the people would not believe any information Ms. Baumgartner was trying to provide in light of her long history of fraud and theft.
She actually, Your Honor, she sent me a picture of the ER.
Okay. All right. So I've had a lot of experience with Ms. Baumgartner. In my own cases, I'm also aware of some of her other cases handled by Judge Hunter. I received, and I'm not sure who sent it, if it was you, Mr. Brown, received some medical information about Ms. Baumgartner. What I've received does not convince me that Ms. Baumgartner is suffering from a medical condition that would have prevented her from being present today. I do, based on my past experience with her, do not believe, absent some other documentation, that her going to the emergency room today is based on a genuine need for emergent medical attention. I find, again, based on my past experience, that it's much more likely that Ms. Baumgartner is just simply trying to avoid this hearing. So I am going to request, Mr. Rolla, that the people issue a bench warrant for her arrest. Once she's arrested, she'll be held at the Otsego County Jail without bond until the court can reset this for sentencing. And I apologize if there's any victims here today for the delay in that. Mr. Roll, anything further on that file today?
No, Judge, thank you.
Mr. Roll. All right, thank you.
Equilibrium Management and Joanne Baumgartner, file 26-42216-LT. Who do we have present for that, please?
Good afternoon, Your Honor. Norman Whitty on behalf of the plaintiff Equilibrium Management.
Thank you. Do we have Joanne Baumgartner with us? No one is responding to the call of the court. My staff reminds me that Ms. Baumgartner may be at the Otsego County Jail.
All right, we're on the record in People versus Baumgartner. This is file number 266979. The record should reflect that Ms. Baumgartner is present here in the courtroom today. If I could have counsel put your appearances on.
Morning, Your Honor. For the record, I call on behalf of the people.
Thank you, Your Honor. Larry Brown on behalf of Ms. Baumgartner.
Thank you. This is the date and time set for a sentencing matter in this case. We did have sentencing set for last Wednesday. Ms. Baumgartner failed to appear, so the court issued a bench warrant. She was arrested on that, I believe, on June 4th. And so then the court set this for a sentencing hearing today. Ms. Baumgartner, have you had a chance to go through the pre-sentence report with Mr. Brown? You had a chance to go through the pre-sentence report with Mr. Brown?
Yes, sir.
Okay. Mr. Brown, are there any additions, deletions, or corrections?
No, Your Honor, and no challenges to the scope.
Thank you. Mr. Rolla, do the people have any additions, deletions, or corrections?
Just a 6 days credit for incarceration.
Okay, so we would have,
No other challenges as this one.
thank you. Do you have any victims that wish to address the court today?
We do not, thank you.
Anything on behalf of the people for allocution?
Yes, this defendant's a 6-time felon who committed the incident offense, while specifically on probation for effectively the same offense for which he's not convicted. Requiring mail theft conviction was on December 22nd, 2025. Offense date September 29th, 2025, as indicated in item 7 of the adult criminal history. That was pled down from the felony to a misdemeanor. This defendant has 2 prior theft, fraud, identity theft related offenses and convictions, items number 4 and 5 adult record, as well as 3 misdemeanor theft, fraud offenses, items number 1, 3, and 7. While on probation, this defendant continues to present a danger to the community, as evidenced by the 28 new victims who have the misfortune of residing in the same complex as the defendant. It's also worth noting that at least one of these individuals had the packages of medication taken by the defendant, and another had the clothing taken. And as to the others, the defendant already had a prior felony conviction for identity theft. That's by the number 2 and 3 of items 4 of 8, indicated after the probable cause signed by Officer Pugh. When confronted by the police in her apartment and apprehended, was observed to be holding several pieces of mail, with the address is now blacked out with either a black marker and or covered up with white out in what appeared to be an attempt to conceal the victim's original delivery address. In other words, arguably preparations for more future identity theft. Prosecutor's officers provided by defense counsel a copy of the defendant's October 30 neuropsychological evaluation report from Neurobloom Cognitive Health Center. It's worth noting that at page 4, under the heading, quote, executive function and problem solving, end of quote, which apparently is testing designed to evaluate a subject's ability to extract, anticipate, select, plan, experiment, modify, and act upon information in a novel situation. It was indicated that, quote, Ms. Baumgartner scored in the mildly impaired range on the Wisconsin Card Sort Test, specifically that she was able to identify a partial range of possible response options, but was not able to successfully adapt to feedback to complete any response categories, and therefore achieve 0 completed score, thus resulting in a evaluation of severely impaired score. People would respectfully request and submit that this court compare that and contrast that to the presentation by the defendant to her evaluator of her allegedly severely impaired abilities to that at the time of October 30th, 2025 testing, with the abilities the defendant was able to exhibit in instant matter as expressed in the PSI under description of defense narrative, which indicates that while on probation for the same type of offense, the defendant, even though she was caught on video taking mail from various mailboxes of other tenants at Timberlake, first denied her actions, then after a search for apartment disclosed a large quality and quantity of mail addressed to numerous other individuals, stated, as also indicated in her affidavit, that, well, she just wanted to give the mail back. And then asked it that no further legal action be taken. People would submit that such demonstrated actions of planning, preparation, ability to extract information and react to a novel situation of now being caught red-handed, but then without batting an eye to say, oh, how about I just give the mail back without charges being sought, would appear to indicate an individual for whom a much higher score under that testing should have and would have resulted had accurate responses been given at the time of the October 30th testing. Further, there are 5 recommendations that were to be followed as listed under the summary recommendations section to the neurological psychological evaluation at pages 5 and 6, which was prepared approximately 1 month before the defendant's prior mail theft offense in September of 2025. These included, but were not limited to, the setting up of the management of medication assistance plan, as well as arranging for appointment of a durable power of attorney. But unfortunately, there has been no indication, clearly no clear indication, as to whether some, all, or any of these recommendations by the licensed psychologist, Ms. Vanderholt, were ever implemented by the defendant in any way. In fact, as the medications from one of the victims was taken by the defendant, that would be contrary to the recommendations. Under the above circumstances and under the recommendations section, a county jail sentence sanction is recommended. This recommendation appears to be somewhat in conflict to the express language at the end of the evaluation of plan section of the PSI, the defendant, which states, quote, given her repeated failures on probation, commissions of a new offense of the same nature, and concerning behavior related to victim information, community supervision is not appropriate. End of quote. This defendant has then demonstrated that community-based supervision alone is insufficient to deter her conduct and or to protect the community. People would submit more punitive sanctions are now warranted. Sentencing guidelines in this offense is 10 to 28 months. While the people will acknowledge that in the instant matter, the sentencing recommendation of county jail time is within the sentencing guideline range, as this is now the defendant's 7th felony, was committed while she was on probation after already being given the benefit of what would have been then her 7th felony, who was reduced to a misdemeanor offense in order to protect society from this defendant's continued larcenous behavior. An MDOC sentence also would not be appropriate. Thank you.
Thank you, Mr. Brown.
Thank you, Your Honor. I have represented Ms. Baumgartner in the past. I think it is clear to the court she does have some physical issues. There was a medication list submitted with the PSI, which is 2 pages long. I think that's the longest medication list I've ever seen. So she is taking multiple medications. There is some mental health issues that she does suffer with. She's got some dementia. It was difficult going through PSI with her. She didn't quite understand a lot of it. Doesn't remember a lot of things that happened. My guess is something significant happened back in 1996. It looks like there was a 20-year gap in her criminal history from 96 all the way up to 2018. I'm not exactly sure what she went through, but it has taken a toll on her. She is advising me that her hand is such that she can no longer functionally use it. She has difficulty doing normal activities of daily living, showering, eating, pretty much anything because of the immobility of her hand. So there are a lot of health issues going on, as well as mental issues. Why you would go into an apartment and just start taking other people's mail, I really don't know. I would say that is indicative of some sort of a mental health issue. So I would ask the court to take that into consideration. She is terrified, and she's mentioned this multiple times. She has been to Huron Valley before, which is Michigan's only women's correctional facility. I don't know how much the court follows the news, but I know that Ms. Baumgartner does. And The institution is currently under investigation by the governor and the attorney general. There have been 3 deaths in that facility in as many weeks. And I think it is terrifying her that if she goes to the MDOC, she's just not going to come out alive. So I would ask the court to take those things into consideration.
Thank you, Ms. Baumgartner. Was there anything you wanted to say today? No.
Okay, stairs upstairs.
Can you explain why you were taking everybody's mail?
I can't.
Okay.
I don't even remember.
Okay. All right. All right. Well, Ms. Baumgartner, I did read through the pre-sentence report, so I'm familiar with why you are before the court today. I'm familiar with your background and your circumstances. You've been in front of me before for other cases. And so I take all of that information into consideration along with what the lawyers have had to say here today and yourself. It's clear to me, I mean, you've had a long history of victimizing other people in various different ways. This is a new way, but the amount of mail that you were taking, and then your efforts to try and obtain identities from people, that's something that's very disconcerting to the people, other people involved. And it can be harmful, as indicated. At least some of the things that you took were medications that were needed by someone else. And we have tried a number of times through probation, through community sanctions to try and address your behavior. But it's clear to me at this point, at your age, there really isn't anything that I could say here in court. And I don't think anything that we could do through probation or anything else that would correct your behavior. I find it difficult to even know what's really happening with you, if there's really something wrong physically or mentally, or if you're just kind of making it up. Like, you're acting like you can't hear me a little bit today. I don't even know whether to believe that, because you, the way that you've gone about things over the past few years, it's hard to tell whether things are really happening or whether you're just making them up. And so it makes it hard for me to accept, other than perhaps some health problems, which I do have doctor's confirmation of, although some of that might be just based on your own reporting to the doctors and may not be accurate either. But regardless of what physical things you have going on, none of that has stopped you from continuing to victimize other people. And I think in terms of our community, the only way to prevent that going forward is to have you removed from the community. Because I think if you have a community sanction or you're released on work camp or something like that, that you will just continue to victimize people. And, you know, even though you do have some health problems and you're getting up there in age, I'm not convinced that either of those things would stop you from engaging in the kind of conduct that you did in this case, again, or some other type of conduct to victimize people. So for those reasons, I do think that a Department of Corrections sanction is appropriate here based on your actions here, based on your past history, and based on what the court views is unlikely prospect of rehabilitation, and more likely what's necessary is a sentence, again, to remove you from the community and prevent further victimization. So the court is going to sentence you to 28 months to 7 years, 6 months in the Department of Corrections. You do have credit for 8 days served. You do have the ability to seek an appeal of the sentence. And Mr. Brown, you provide Ms. Baumgartner.
I have, Your Honor, and I have tendered that acknowledgement.
Mr. Rolla, is there anything else that we need to address today?
No, Your Honor, thank you.
Mr. Brown?
Excuse me. No, Your Honor. Thank you.
Thank
Judge,
you.
are you ordering fines and costs?
Yes.
Oh, Judge, was there restitution order for prescription medication?
I didn't see that in here.
I didn't see a request that came into our office. I didn't. They may not have done so.
The court will preserve that issue if there is something you could file a motion.
I think it was recovered though, and I think that's probably the reason it wasn't requested. I just hadn't seen it included in the picture.
So, and in addition, the court will order a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. And Ms. Baumgartner, you are remanded to the custody of the state at this time.